Hello and welcome. Today, we are diving headfirst into the global hiring maze. Now, if you think fairness in hiring means the same thing no matter where you are in the world, you are in for a surprise. We're going to see how history, culture, and law create these completely different rulebooks for employers. So, you probably think that the basic ideas of anti-discrimination are universal, right? But what if I told you that a hiring practice that is totally illegal in one country could actually be required in another? Yeah, it is a whole world of difference out there. So here's our roadmap for today. We're going to look at who even counts as disadvantaged, then how you actually prove discrimination. After that, we'll hit the really surprising divide over preferential treatment, and finally, we'll wrap up with why any of these global rules even matter. And our guide on this journey is this landmark study that looked at 22 different countries. What it found was this fascinating, kind of complicated patchwork of hiring laws, where every single one is shaped by its own unique national story. Okay, let's start with a place many of us are familiar with, the United States. Hiring there is hugely influenced by a web of strict laws and the constant threat of lawsuits. But as we're able to see, this super legalistic approach, it's actually the global exception, not the rule. So, first big question, who are these anti-discrimination laws even designed to protect? Well, the definition of what a disadvantaged group is, it changes completely depending on where you are in the world. For instance, in countries with a history of colonization, think Australia, Canada, the US, disadvantaged status is often all about Indigenous history. It's defined by who the original inhabitants of the land were. But then you hop over to Europe, and the story is totally different. There, disadvantaged status is often defined by more recent immigration, a lot of it from post-World War II guest worker programs. So you see communities from places like Turkey and North Africa becoming the focus of these laws. And in other parts of the world, the lines are drawn by these really deep-rooted social and religious histories. In India, it's the caste system. In Turkey, it's about religious minorities. And in Israel, it's about groups like Palestinian Arabs and Sephardic Jews. And get this, history can even flip the whole concept of minority right on its head. Look at post-apartheid South Africa. The black population makes up almost 80% of the country, but legally they're classified as the disadvantaged majority. It just goes to show you that these terms are about historical power, not just numbers. So, the bottom line here, there is no single universal definition of disadvantaged. It can be about native status, recent immigration, race, religion, even what language you speak. Every single law is really just a mirror reflecting a country's own unique past. Okay. So we figured out who is protected, but the next big question is, how do you actually prove discrimination? It turns out the basic rules for that are also wildly different across the globe. And a key idea here is something called disparate impact. All that means is that a hiring practice is considered illegal if it harms a protected group. And this is the important part, even if no one ever intended to discriminate. The focus is all on the outcome, not the motive. Now, in most of the countries studied, just showing that negative effect is enough to make a case. The burden of proof then shifts over to the employer. But in a few places, like Taiwan and Turkey, the person making the claim has to prove the employer intended to discriminate. And believe me, that is a much, much higher bar to clear. But here's another wrinkle. Even in countries that recognize disparate impact, their approach is way less rigid than in the US. See, America has these very specific statistical tests, like the famous 4/5 rule. Elsewhere, the concept is there, but how they apply it is a lot less mathematical. And that brings us to what is maybe the biggest, most surprising divide of all, an area where the US is a true outlier. We're talking about preferential treatment. So let me just ask you this. Should it be legal to give a hiring advantage to a candidate from a disadvantaged group? Using things like quotas or adjusting test scores? Well, your answer probably has a lot to do with where you grew up. Because in the United States, preferential treatment is a hard no. It's explicitly banned by the Civil Rights Act. But in pretty much every other country in this study, it's either permitted or, in some cases, legally required. What is banned in the US is standard practice almost everywhere else. It's a huge difference. And here's what that looks like in the real world. You've got hard quotas in France for people with disabilities, in Taiwan for Aboriginals, and in India to address caste imbalances.
Other countries allow what you might call softer preferences, like using different cutoff scores on a test or letting protected status be the deciding factor in a tiebreaker.
So, okay, we have all these different laws on the books, but what's the actual real-world impact? How much do these rules really matter when it comes to who gets hired?
Well, in some places, the law is a massive force. Take South Africa. Its legal framework was heavily, and I mean heavily, influenced by the US model, and that fundamentally reshaped how companies there design their entire hiring systems.
But then you look at other places, and it's a completely different story. In Korea, for example, researchers found that, frankly, compliance with discrimination law just doesn't seem to be a major concern for employers. They found applications that still ask for photos, your age, or even what your parents do for a living.
So, if the local law isn't the main driver of change, what is? Well, very often it's the influence of multinational corporations. When these big global companies set up shop in markets with weaker laws, they bring their own HR practices with them. That means modern, fair hiring practices often spread through business influence, not legal pressure.
All right, let's just quickly recap the big points. First, what's considered fair is all about local history. Second, the US is a real outlier with its total ban on preferential treatment. Third, the rulebook for proving discrimination changes from place to place. And fourth, in a lot of the world, big business trends can actually have more impact than local laws. And all this leaves us with a really big question for the future. As work gets more global, more remote, are all these different legal systems going to start looking more alike? Or is this global hiring maze just going to get even more complicated? Thanks for digging into this with me.